So I have an update for you on the California handgun roster cases, which recently were heard before the Ninth Circuit. So let's talk about this. But real quick before we jump into this video, if you think the handgun roster is clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they are huge Second Amendment supporters. They have dedicated rows for FPC and GOA, and if you order some of those coffee brands for FPC or GOA, some of those proceeds go directly to those organizations so they can file lawsuits like this one. So again, amazing coffee, huge Second Amendment supporters, and if you order using the links down below and you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, I'm going to be giving you an update on the California handgun roster cases, which just had oral arguments which took place before the Ninth Circuit. If you're not aware, recently a federal district court judge in California issued a preliminary injunction against the safety features requirements that the state of California has in place in their Unsafe Handgun Act. Now, the two cases we're going to be talking about are Bolin v. Bonta and then also Rena v. Bonta. Bolin v. Bonta is a CRPA and a Michelle and Associates led case. It also has Reno May as a named plaintiff. And the lawsuit challenged the constitutionality of the handgun roster, the safety feature requirements within the handgun roster, and it challenged them using the Supreme Court's recent decision in Bruin. Again, there is also the Rena v. Bonta case, which is an FPC case, and it does a similar challenge. Both of these cases were heard in front of the Ninth Circuit, a 3-judge panel, and there were some positive things that we need to discuss, and I'm going to give you my general impressions about how I think they will rule. Now, for those not aware, in California, there is a law which places certain requirements on handguns for them to be deemed safe for sale to essentially average law-abiding people. The UHA requires that handguns be drop tested, they must have microstamping technology, a loaded chamber indicator, and then also a magazine disconnect. Any handgun that does not undergo these tests or lacks these features is deemed unsafe. It cannot be sold to just average people in California. In the Bolin lawsuit, the plaintiff sought a motion for a preliminary injunction against the UHA's safety feature requirements, which included the magazine disconnect, the loaded chamber indicator, and then also the microstamping requirement. Well, recently, a federal district court judge, Judge Cormac Carney, granted the Bolin motion for a preliminary injunction. California did receive a stay from the Ninth Circuit, but only against the decision and its impact on the chamber indicators and then also magazine disconnects. The state of California, interestingly, almost conceded the microstamping requirement, likely because of how infeasible it is and how we all know that microstamping isn't a real thing. As many of you are aware now, multiple handguns have made their way onto the roster if they have magazine disconnects or loaded chamber indicators, and that is because there is still an injunction on the microstamping requirement, so that's not in effect, so there are some handguns that are currently making their way on the roster. Now, after the Bolin decision, soon after, pretty much, we received another positive decision from Judge Dana Sabra in the Southern District of California, and that was in the FPC Rena case. Well, both of these cases have now made their way to the Ninth Circuit in a 3-judge panel because we knew California would appeal those decisions. These cases were essentially kind of consolidated in a way, and they were heard before a 3-judge panel in the Ninth Circuit. The Ninth Circuit panel was not super favorable. It didn't look like it was potentially going to be in our favor because the 3 judges on the panel which heard the cases were judges Berzon, Rawlinson, and then Breeze. So the makeup of the judges and the expectation was that it was going to be an obvious 2-to-1 lean in favor of the state of California. You had 2 left-leaning judges who are likely going to rule in California's favor. So today we had the oral arguments. Today I watched the oral arguments. And the oral arguments, in my opinion, probably went as good as you could expect it, especially when you have 2 left-leaning judges on the panel. Judge Berzon, who is left-leaning and has been on multiple 2A case panels, who has ruled against the 2A in the state of California and has in the past not been favorable at all, she did give some pushback against the state of California, primarily on the microstamping requirements. It seemed like Judge Berzon was almost acknowledging that at the very least microstamping is infeasible and that the state of California put forward no evidence to show that this type of technology is viable at all. The temperature of the judges to me seemed like, in my opinion, they were at very least leaning towards upholding the decision of the lower courts, striking down the microstamping requirement, but maybe leaving in place the other requirements like the loaded chamber indicator and then also the magazine disconnect. Also, interestingly, there was some discussion about whether the lower courts committed an error by issuing a mandatory injunction, or the argument by the state of California, and one of the judges was that this was a mandatory injunction, which forced the state of California to do certain things like test certain handguns now. To me, this signals that at least this one judge kind of wants to get out of this case on a technical issue. But even Judge Berzon, again, the other left-leaning judge, seemed to reject that type of idea. Judge Berzon pushed back against this concept by saying that the state in no way can say this is a mandatory injunction because it's not forcing the state of California to do anything specifically. Instead, it tells them what they cannot do. And at the very least, the result of the injunctions that is currently in place essentially forces California to apply the roster evaluations in a way that's already set under current law. So it doesn't really force them to do anything. The laws that are in place is what requires them to do something. Now, all of that is to say that this is still likely not going to be a two-way slam dunk in our favor. I think this case is still overall going to be against us and against the Second Amendment. Again, this is not a favorable panel. However, I do think that the micro-stamping requirement will probably not survive this panel, even though it's left-leaning. The panel to me almost seemed to concede that micro-stamping is a big issue, that it's not feasible at all, and that California has not defended it during this whole process. But Judge Berzon really did decide to focus on trying not to lump all the requirements together. Instead, what she seemed to want to do is treat microstamping very differently from magazine disconnects and loaded chamber indicators. She seemed to take the position that since these technologies like magazine disconnects and loaded chamber indicators are more feasible than microstamping, then it can be more easily applied in the favor of the state of California. And I'm saying that she's probably going to rule in their favor on those two requirements. Now, keep in mind this entire two-way analysis is supposed to be under the Bruin framework, which is text as informed by relevant history. And that is the current standard that's in place. The argument is that since owning a handgun is conduct protected by the Second Amendment, then any restriction like the roster is putting in place must be justified using historical laws, which date back to 1791. And at best, the state of California needs to put in place or put forward at least some sort of historical analogs. Now, in my opinion, Judge Breeze seemed to want to keep the questions on the panel in line with the Bruin analysis, looking at Bruin and Heller, the textual and the historical arguments and analysis. However, Judge Berzon kept wanting to take the arguments towards feasibility of technologies, what's in the public's best interest. So again, you can see the stark contrast between someone who's wanting to apply Bruin and someone who's wanting to apply something completely different. I will say that the pro 2A attorney, Erin Murphy, she did an amazing job. She pushed back against these types of arguments that were being presented by Judge Berzon. Erin Murphy has argued multiple California 2A cases. I've seen her argue multiple cases. She always does an amazing job. You can tell not only does she understand the Second Amendment, understand these laws in question, but also she understands firearms themselves, which really helps during these arguments. But overall, my takeaway from these arguments before the Ninth Circuit was that this probably went as well as you could have hoped for, especially with a non-favorable panel. I still think that there will be a 2-1 decision in favor of the state of California. I think microstamping will not survive this decision. I think the loaded chamber indicator and then the magazine disconnect will be found constitutional by this panel. But ultimately, I think this case is destined to go to the Ninth Circuit en banc panel and then eventually up to the Supreme Court. But now we're going to wait for the decision, and if you wanted my opinion, that's where I think this is going. I think it's going to be 2-1 in favor of the state of California, but microstamping will not survive. So again, just my initial takeaways after listening to the Ninth Circuit oral arguments in the handgun roster cases, both the Renna and Boland cases. If you would like, please donate to organizations like CRPA. CRPA is the ones behind the Boland case. They filed that lawsuit. They got the original win in the Boland lawsuit. Again, support those state orgs that are fighting for your rights here in the state of California. I will link down below where you can donate to. And again, if we get any more information, if anything else develops, I will let you all know. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.